What is good for the goose is good for the gander. In the context of secularism, what is good for a Christian is good for a Sikh, is good for a Muslim. But when it comes to secularism as practiced in India, what is good for a Christian, a Sikh, and a Muslim is not good for a Hindu. The preamble to the Constitution of India begins with the following declaration. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular democratic republic, and so on. But is the Indian state really secular? No, it is not. Consider Article 29 of the Constitution. It protects the interests of a section of citizens with a distinct religious, cultural, or linguistic identity by granting them the right to protect their language, their script, and their culture. The article intends to preserve and protect the innate pluralism that makes India the fabled land of diversity. In conjunction with it, Article 30 empowers the minorities with the right to establish and administer their own educational institutions. However, there is a catch. While the protection against discrimination under Article 30 is extended to institutions of minorities, it does not say anything about the institutions of the majority. If one sees the drafting history of these provisions in the Constituent Assembly debates, there would be a clear sense of deja vu, where minority right activists exercised disproportionate influence. In close similarity to present day politics, the Constituent Assembly, perhaps in order to quell these misplaced insecurities, adopted the said provisions. Now, what really constitutes a minority? The social reality of India, demographically dominated by people adhering to what is known as the Hindu religion, with its hundreds of thousands of sects, castes, and subcastes, do not yield at all to this imposition of majority-minority divide. As an example, how can a Vaishnav from Tamil Nadu and a Shakt from Bengal be clubbed under one category of majority, in complete disregard to their cultural distinctiveness? Thus, by forcing an artificial definition that is incongruent with reality, the Indian state has kept the country divided along religious lines, perhaps just as the British colonizers had intended. Ironically, this anomaly was brought to the attention of the Parliament in 1995 by none other than Syed Sahabuddin, an Indian parliamentarian most remembered for his pivotal role in getting Salman Rushdie's Satanic Verses banned, and also in overturning the famous judgment of Shahbag. Perhaps Sri Shahabuddin preempted the grievance it would cause to the majority community and wanted to prevent any Hindu-Muslim conflict arising from it in the future. It would be worth considering here that if India is a secular state, it implies that it treats all religions equally. Accordingly, the Republic does not have a state religion, in which case, making the distinction between one religion and another, regardless of the number of adherents of each, makes absolutely no sense. As a corollary to this, if the Indian state insists on making a distinction between minority and majority when it comes to funding their institutions, then isn't it, in a way, admitting an adherence to Hindu religious beliefs? It is, theoretically speaking, but it is not in practice. Because under Article 28, the state prohibits religious instruction in public educational institutions, and rightly so. But again, there is a problem. By categorizing all the ancient civilizational knowledge of India, whether it is of mathematics, psychology, history, medicine, as religious, the modern state has effectively severed the umbilical cord of its citizens with their own priceless heritage. Far from being the custodian of the Indian civilization, the Indian state has turned into its principal enemy. Wait, there's more to it. Article 27 of the Constitution forbids the state from levying taxes on citizens for promotion or maintenance of any particular religion or religious denomination. But consider this, when the Minority Affairs Ministry sets up yet another scheme for the empowerment of minorities, who funds this whole arrangement? The taxpayers, of course. So while the government does not divert your tax in the service of a religion directly, it still does so, albeit indirectly. Then, of course, there is the famous case of only Hindu temples being under governmental control, while other religions enjoy complete freedom in running their own institutions without state interference, as guaranteed by Article 26 of the Constitution. In effect, the government and the courts are controlling Hindu temples and imposing their own synthetic, westernized notions of morality and rationality only on Hindu beliefs and practices. Articles 26 to 30 of the Constitution were meant to give religious freedom to the people of this country, but the same articles have been misused to deny that freedom to a vast majority of the Indian population. If this is not a fit case for constitutional reform, I don't know what is. I am Kanu Agrawal, advocate at the Supreme Court of India,